Good morning. Good morning again to discussion some case law precedents of House of Law. And today we're going to discuss about a very important matter of copyright law, the substantial part of work. So it has been going for the long discussion how to define an important part of a work, whether the copyright law only protects the expression of thought. It doesn't protect the expression of idea. So how can we define it? And today's discussion, we're going to see a House of Law decision, Judgment Designer Guy Limited versus Russell William Textile Limited Trading, Washington, D.C. So here is the case. Law Bingham of Cornhill. My law. In common with all your lordship, I agree that this appeal should be allowed and the judge's order restored. And a good order that the appellant have the cause before the House and in the course of appeal. But there are some differences of approach among my notable and learned friend most expert in this field. I venture to summarize very shortly and simply my own reason for reaching a conclusion I do. For that purpose, I gratefully adopt the account given by my noble and learned friend Lord Scott of Foscote of the facts and background of the case and a judgment delivered by the judge and court of appeal. The law of copyright set on a very clear principle that anyone who by his or by her own skill and labor create of original work of whatever character show for limited period enjoy an exclusive right to copy that work. No one else may for reason with what a copyright on has shown. It is not now disputed at DGL Asia Design were an original product of DGL skill and labor. That is not to say DGL drew no inspiration from elsewhere. There's no new thing under the sun. But the design was sufficiently original to earn copyright protection. DGL complained that RWT in its Marguerite design has copied the Asia design and so infringes copyright. RWT strongly contested that accusation at trial, seeking to show that it had not would not have copied the Asia design. Thus, as I infer, were the central issue at the trial, but the judge rejected RWT evidence. Relying the man on similarity, holistic between the Marguerite and Asia design, he concluded in round terms that the one has been copied from others. That finding did not conclude the case in favor of DGL, for realistically recognizing that no real injury is done to the copy owner, if no more than an insignificant part of the copyright work is copied. Section 16(3) of the Copyright Act 1988 provide that to infringe, an act must be done in relation to the work as a whole or any substantial part of it. So the judge had to consider whether RWT has copied DGL work as a whole or any substantial part of it. Since the judge has based his finding of copying largely on the similarity between the two designs, it would have been very surprising if he had found that RWT had not copied a still substantial part of DGL design, but it was necessary for the judge to consider that question, and he did. He found that there has been copying of substantial part. Why not accepting a judge's finding of copying? RWT recognize the virtual impossibility of dislodging it in a court of appeal and did not challenge. RWT challenge was accordingly directed to the judge, finding that a substantial part of the Asia design has been copied. The Court of Appeal upheld this challenge, but in doing so, it seemed to me I fell into error. First, my analysis of individual features of the two designs and highlighting certain dissimilarity of the court failed to give effect to the judge's conclusion, nor challenge before it that the similarity between the two designs was so marked as to warrant a finding that one had been copied from other. What the finding of copy did not in theory conclude the issue of substantiality, or the fact here is what almost bound to do so. Secondly, the Court of Appeal approaches the issue of substantiality more in the manner of the first instance court, making an original finding of facts than as an appellate court revealing finding already make an very important respect not challenge. This was not for the Court of Appeal to embark on the issue of substantiality first, unless the judge has misdirected himself, which in my opinion he had not. There were, I conclude, no ground for interfering with the judge's conclusion. We now go into the second argument of Lord Hoffmann. My lord, I have had advantage of reading in draft of speech of my noble and learned friend Lord Bingham, Cornhill. I agree with it, but in view of the fact that we are differing from court of view, I shall give my reason in rather greater detail. The issue. There is no dispute that a plaintiff will entitled copyright in artwork of the fabric design Asia. The infringement to which the plaintiff complained was that for the purpose of creating his own design, Marguerite, the defendant has copied a substantial part of Asia. There were accordingly two main issues at the trial. First, what, if anything, had a design of Marguerite copied from Asia? Secondly, did what had been copied amount to the whole or substantial part of Asia? So what are different? When we define the whole or a substantial part of the work, very, very important, because now the copyright law not consider only to the content of the work, but also the meaning, content of the copyrighted. And thus will create very, very controversial issue. The finding of the Church 1998 on the first issue. The position taken by the defendants at the trial were that its designer has copied nothing. Mr. Alan Williams, the director in charge of design, and Miss Peterson, who produced the artwork under her direction, it said in evidence that they were not aware of Asia at the relevant time. The judge should not believe him. He fought them on satisfactory witnesses and decided that they must have copied. In coming to this conclusion, we rely first upon similarity of design, which went far beyond the similarity which would be expected simply from both being based on an impressionist style or from both being based on a combination of strip and scatter flower leaves. A listed dissimilarity as follows as page 813. First, this fabric consists of vertical stripe, which space between the stripe equal to the width of the stripe, and in each sprig flower, and leaves scattered over between the stripe to give the same general effect. This is painted in a similar neo-impressionist style. It uses the broomstick technique, generally the use of one brush to create a stripe, so the brush mark again the gesture. In each fabric, the strips are formed by vertical broadstock and hair-rough act which merge into the background. The fabrics of the battle are formed with driest broadstock and are executed in a similar way, somewhat in the form of comma. In each fabric, parts of the color of the stripe show through some of the petal, technically called the resist effect. In each case, the center of the flower head are represented by the stone block rather than a realistic representation. In each fabric, the leaves are painted into distinct shades of green with a similar broadstock and are scattered over design. Secondly, the church relied upon the interference to withdraw from the fact that the defendant's designer has given a false explanation of provenance of the design. Thirdly, he relied as similar fact evidence upon the fact that he had at his file copied a design from another competitor and falsely designed nice on the second issue. The judge summarized the submission of counsel for the defendants. This took the traditional form of dissecting the ICA design to its component elements, adjoining region with each element, such as stripe, flower, etc., lack of originality, or has in some respect not been copied, and concluding that those elements which has been copied were not a substantial part. The judge rejected the submission. He said at page 828 that the work should be considered. It's the combination of the flowers and the stripe, the way in which they relate to each other, the way in which they were painted, and the way in which there were a resist effect, which make the overall combination of copyright of a substantial part. The Court of Appeal. In the Court of Appeal, Mr. Fish received for the defendant considered that he could not challenge the judge's finding on copying. Only the issue of substantiability therefore remained alive. The Court of Appeal said that substantiability were a question of judgment on which they were in as good a position to form a view as a judge. They disagree with him for three reasons. First, visual comparison. Second, dissection. And thirdly, the idea rather than expression. So what is the first one? Maurice L.J. said when he compared the two designs, it appeared to him that the one did not improve copying of the substantive part of the order. They just do not look sufficiently similar. Paragraph 30, Clark L.G. agree. Dissection. Maurice L.G. with whom Off and Claire agree analyzes the component part of the design on the above hand stripe and flowers. The layout of flowers in Marguerite are different, and the flowers themselves were not copied. They left only the idea of stripe and flowers, which was original. The brushwork and resist effect involved the use of comparable technique, but the visual result was in certain respects different. The effects which were the same did not add up to a substantial part. Idea is right and expression. Maurice L.J. said at paragraph 37 that the plaintiff were not entitled to monopoly in ideas. The defendant copied the idea. They adopted the same technique, but did not copy a substantive part of expression of idea. My lord, I must examine each of these three reasons. What about a visual comparison? Visual comparison. The second about dissection, and the third the idea and expression, and then appellate function. Right. So we have many elements to discussion here. So we just focus on the idea and expression. It's often said, as Maurice L.J. said in this case, that copyright subsists not in idea but in the form in which the idea expressed. The form in which the idea expressed. The form. The distinction between the present idea by a place in agreement on trade-related aspects of intellectual property trips to which United Kingdom as party. Copyright protection so extend to its present, not to the ideas. Nevertheless, it needs to be handled with care. What does this mean? As Lord Hespham of St. Malabon say, LP Plastic Ltd. Swiss Products Company, 1979. It all depends on what mean by ideas. What mean by idea? Very, very important. And we can see the UK jurisdiction usually mention about international law, and then they cite many things concerned to the problems, and that really interesting when we refer to some case law in order to understand very clearly about the case and the case. Some jurisdiction it doesn't give the the effect for the case in that really bad, isn't it? So we go to review that case later. Plainly, there can be no copyright of an idea which is merely in your hand. It had not been expressed in a copyrightable form. And a literary, dramatic, musical, or artistic work. But a distinction between ideas and expression cannot mean anything so trivial as that. On the other hand, every element of the expression of an artistic work, unless got there by accident or compulsion, in the expression of idea on the part of the authors, is represent a choice to paint stripe rather than polka dot, flowers rather than tadpole, use one color and prose technique rather than another, so on. The expression of this idea protected both as a cumulative whole and also to the standard to which they form a substantial part of the work. Other terms, substantial part might suggest a qualitative test or at least to the ability to identify some discrete part, which on quantitative and qualitative ground can be regarded substantial skill upon authority. That neither is the correct test. Ladbroke Football Ltd. William Hill Football 1961 established that sustainability depends upon quality rather than quantity. It's very important. Very important decision. And there are numerous authorities which show that the pork, which is regarded as substantive pork, can be a feature or combination of feature of work abstracted from it rather than forming discrete pork. That is what the church found to have been copied in this case. Or to take another example, the original element in the plot of a play of novel may be a substantive pork. Thus, a copyright may be infringed by a work which did not reproduce a single sentence of the original. If one asks what is being protected in this case, it is difficult to give any answer except that it is an idea expressed in a copyright work. My lord, if one examines the case in which the distinction between idea and expression of ideas having given effect, I think it will be found as a support to quite distinct propositions. The first is that a copyright work may be express certain ideas which are not protected because they have no connection with the literary, dramatic, musical, artistic nature of work. It is on this ground that, for example, a literary work describes a system or invention does not entitle the author to claim protection for a system or invention as such. The same is true of an inventive concept expressed in an artistic work. However striking or original it may be, ordered or in a use absent of the patent protection, free to express is in work Neon C. Glenny Ltd. DRJ UK Ltd 1984. The other proposition is that such an idea expressed by a copyright work may not be protected because under the idea of literary, dramatic, or artistic work nature, they are not original. And so component placed to form substantial part of the work, Henry's Lawrence, 1890, is a well-known example. It is on this ground that the mere option of combination strain flowers would not have been amounted to a substantial part of planted work. At that level of abstraction, the idea toward the press in design would not have represented sufficient of author skill labor and to abstract copyright protection. So the problem is very, very, very complicated now. Generally speaking, in these cases of artistic copyright, the more abstract of symbol and copy idea, the less likely to be constitute a substantial part. Originality in the sense of that contribution of the author's skill and labor tend to lie in the detail with which the basic idea is presented. Copyright law protects forces better than hedge law. In this case, however, the element which the judge found to have been copied went well beyond the banner, and I think that the judge were amply justified in deciding that the form a substantial part of the originality of the work. You are searching the article comment reported by Nguyen Thái Cường from Institute of Intellectual Property and Competition. And today's problem is about the substantial part of the work. And as we can see, it's very, very complicated issue and cannot resolve in one term. So it must be a long-going discussion. So we're going to see the special thing of substantial part of the work only. So what the judge had found that the defendant design incorporated feature taken from the copyright work. The question is whether what has been taken constitute all a substantial part of the copyright work, which is a matter of impression, or whether the part taken is substantial part must be determined by its quality rather than its quantity. It depends upon its importance to the copyright work. It does not depend upon its importance to the dependent work. As I have already pointed out, the pirated part is considered on its own. See Ladbroke Football Ltd, Bingham Football Ltd, 1964. And it's important to the copyright work. I suggest there is no need to look at the infringing work for this purpose. The Court of Appeal were concerned only with this second stage. They were not entitled to reverse judgment, finding that the defendant design reproduced feature of the copyright work, nor his identification of the feature in question. The only issue were whether those features represented the substantial part of the copyright work. A visual comparison of the two designs were not only unnecessary, but likely to mislead. My noble and learned friend Lord Scott Foscote had drawn attention to the difference between the copying of a discrete part of the copyright work and the auto copying of the whole, or the copying with or without modification of some, but not total feature of copyright work. The distinction is not material in the present case, whether or not it's alleged that discrete part of the copyright work has been taken. The issue of copying and substantiality are treated as separate question, where, however, it is alleged that some, but not at all, the feature of copyrighted work has been taken. The answer to the first question is we almost inevitably answer both. If the similarity are sufficiently numerous or extensive to justify an interview of copying, that are likely to be sufficiently substantial to satisfy this requirement also. So we're going to see what a substantial part of the works is very, very important. The Deputy Judge, in a conspicuously clever judgment, came to the conclusion that the Marguerite design has been copied from Asia design. This conclusion of copying was not challenged in the Court of Appeal and is not challenged before Lordship. Upon taken in the Court of Appeal successfully, as it turned out, were substantiality upon Section 16.3 of the Copyright Act in 1988 provide that reference to this part to doing of an act restricted by the copyright in the work or to doing of it. In relation to the work as a whole or any substantial part of it, and either directly or indirectly. The Court of Appeal were persuaded that although there has been copy, as I have said, the Deputy Judge finding a factor to that effect were not challenged. The copying did not extend to the copying of a substantial part of Asia. Maurice L.J., who gave a leading judgment in the Court of Appeal, succinctly star RWT case thus. RWT case on this appeal is quite simply that notwithstanding such copying and notwithstanding such similarity, the claim that RWT infringed the copyright of the Asia. In the painting of Asia failed because there was no copy of the whole of the painting of Asia. Such copying, there were a part of a painting of Asia did not extend to a substantial part. And in a setting to the manner in which this issue of substantiality should be approached and whether the Court of Appeal answer on the issue were right. It is necessary, in my opinion, to start with the just finding that copying was established. What was in that finding to have been copied? Clarity and to the answer to that question must receive the question as to whether what was copied or whole or substantial part of the copyright work. So, many elements have been writing out. So now we go to the, in a case of this sort, what populational concept of substantiality have to play? Substantiality, Section 16 of 1988 Act say that copying a copyright work is a copyright infringement if the copying is of the work as a whole or any substantial part of it. Section 16.3 may come into play into quite different type of case. One type case is obviously when identifiable part of the whole but not work has been copied. For example, only section of a picture may have been copied, or only a sentence or two, or even only a phrase from a poem or workbook, or only a bar or two of a piece of music may have been copied. See the example given at page 88, 89, paragraph 2, Letty, Prescott, Victoria, monologue copyright design, with for convenience, I will refer at Letty. In cases of that sort, the question whether the copying of a part constitutes an infringement depends on the quantitative importance of the part that has been copied, assessed in relation to the copyright work as a whole. In Ladbroke Football Ltd, William Hill Football, Lord said at page 276 that the question whether he has copied a substantive part depends much more on the quality than on the quantity of what he has taken. The present case is not a case of that type. Judge does not identify any particular part of a sheet and how that part has been copied. Finding is copying related IC whole. The other type of a case in which the question of substantiability may become relevant, in which the copying had not been an exact copy of the copyright work, but a copying with modification. This type of copying is referred to in Latin as author copying. A variant of this type of case could be a translation in a literary work into some other language, or the dramatization of a novel. The translation or the play of theme might not have a single word in common with the original, but assuming copyright existed in the original, the copy might well, and in the case of a word-by-word translation, certainly would constitute an infringement of copyright. So, has the infringer incorporated a substantial part of the independent skill, labor, etc., contributed by original author by creating copyright work? So, my novel and learned friend law, Millett has made pawn as one copying has been established. The question of substantiability depends on the relation between what has been copied on the one hand and the original work on the other. Similarity no longer being relevant. My lord, I respectively fully agree that could be so in the first type of case, but in an author copying case, particularly where the final copying is dependent, in the absence of direct evidence upon the interference to be drawn from the extent and nature of the similarity between the two works, the similarity will usually be determinative, not only the issue of copying, but also of the issue of substantiability. And even where there is direct evidence of copying, as for example, where it is admitted that the copier has produced his copy with the original and his evil, the differences between the original and the copy may be so extensive as to about finding of infringement. It is not a breach of copyright to borrow an idea where of an artistic, literary, or musical nature, and to translate the idea into a new work. In auto copying cases, the difficulty is drawing of the line between what is permissible borrowing of an idea and what is an impermissible piracy of artistic, literary, or musical creation of order. In drawing this line, the extent and nature of the similarity between the author, copy, and original work must, it seems to me, play a critical and often determinative role. In particular, this must be so where there is no direct evidence of copying and the finding of copying is dependent on the interference to be drawn from the similarity. In a little Spanish town case, Francis Dan Hunter, around 1963. So is it well established that to constitute infringement of copyright in any literary, dramatic, or musical work, there must be represent two elements. First, there must be sufficient objective similarity between the infringement work and the copyright work or substantive part thereof. For the former to be properly described, not necessarily as identical with, but as reproduce or adaptation of the latter. Secondly, the copyright work must be a source from which the infringing work is derived. And that's the case. In the present case, the similarity between IC and Margaret, as found by the judge, lay in my judgment in determinative role. If the similarity between IC and Margaret were so extensive and such a nature and to justify finding that, in the absence of acceptable evidence of an independent provenance of Margarita, Margaret's work copied from Asia must, in my opinion, following that Margarita design incorporated a substantial part of Asia design, it must follow also that in designing Margarita design, the designer incorporated a substantial part of the skilled labor of Helen Book. The just finding of copying make it, in my opinion, unnecessary for him to go on to ask whether the copying was of a substantial part, but both the judge and the court of appeal engaged in that inquiry. The judge did not, in order to deal with argument that has been addressed to him by Mr. Geoffrey of counsel for RWT at the trial, Mr. Hobbs, as I read the judge describe his argument, was argued that the Margaret white flower had not been copied from Asia, which had been derived via the acetate from Hoffmann cherry blossom design, and that accordingly the white flowers which should be set to one side when considering whether Margaret design has copied a substantial part of Asia design. Counsel pointed out correctly that Asia vertical stripe were not original, but has been derived from Marxist, and to the Maoist vertical stripe differ geometrical and in color from Asia stripe. It followed Counsel submitted that the copying of whatever were original in the Asian design could not be said to be a substantial part of that design. The judge, in rejecting that argument that said at page 328, in my judgment there had been copying of a substantial part, he went on to emphasize that it were the whole work that had to be looked at to determine whether the alleged infringing material adopted the essential feature and substantial of the original, he said. The right approach is to look at the end result of the acetate, the stride work, the modification made by Mr. William, especially making the stride less harsh, and her selection to colorways and the printed fabric that end result in an infringement of painting on which Asia was based. So, we continue the case. again to see what is the substantial part, and that's all about the substantial part of the work. So just go for it. In my opinion, the just approach in comparing Asia the whole work with Marguerite, the end result were correct. And having made the comparison, he expressed his conclusion that it is the design which were copied and has been reproduced. So, what had been copied was the design, and the design was a substantial part. In dealing in this way, with the substantial part argument that has been addressed to him by counsel, just were reaffirming this conclusion that the Asia design has been copied. The Court of Appeal approach to the substantial part issue. In paragraph 12 of his judgment, Moritz LG recorded that counsel for RWT had accepted that he could not challenge the judge's finding on copying and that similarity between the two fabrics described by the judge did exist. He recorded counsel argument that notwithstanding such copying and notwithstanding such similarity, DGL claim should fail because there were no copying of whole of the penny of Asia and such copying were there words of a part of the penny of Asia does not extend to the substantial part. This submission were not, in my view, consistent with just finding of the copying. Moreover, I think with respect to culture, that is introduced a confusion. Culture were arguing the case that if this were one in which only a part of Asia has been copied, but that were not what the judge had held. This approach led to the court into a timing of rejection of a rival design in an attempt to identify part of Asia that had been copied. In led Morris of paragraph 25 to formulate as a question of fact to be determined, did the pre-production of Marguerite involve the indirect copying of substantial part of the painting of Asia? And paragraph 29 of the judgment, Morris referred to those features of the painting of Asia which just considered to have been copied into Marguerite. He summarized them as the combination of flowers and stripes, the way in which the flower stripe related to other, the way in which flower stripe are painted, and the resist effect. So, conclusion. Now we go to conclusion. In my opinion, there are two respects in which the Court of Appeal approach went wrong. First, the conclusion seemed to me to contradict the just finding of copy. More important, however, the approach whereby the constituent feature of the rival design were isolated from the whole and the compare with one another was, in my judgment, in a case where copying has been found, established, and the findings were not under challenge, wrong in principle. The Margarita design were an altered copy. The question whether the copy constitute an infringement. This raised a question of substantiality, but a question that had to be determined by comparing Margarita as a whole with Asia as a whole. Did Margarita incorporated a certain part of the skilled labor expanded by the design of Asia and producers? Just as far that did. Could not otherwise have made his finding of copy. There has been no direct evidence of copying, and the judgment finding has been based on the existing similarity between Asia and Margarita. The similarity coupled with the opportunity to copy, and in the absence of any acceptable evidence from RWT and to an independent provenance for Margarita, has led to the judge to conclude on a balance of probability that Marguerite has been copied from Asia. If the similarity between the two works was sufficient to justify the inference, that's what had been copied from the other. There was, in my judgment, no further part of the concept of substantiality to play. The thrust of Morris LJ judgment in the present case suggests that he disagree with the basis on which the judge had a right and his finding copy. If the judge finding or copying has been challenged in the Court of Appeal on the ground that the similarity between Asia and Marguerite were not sufficiently substantially to justify the interference that Marguerite has been copied from Asia, the challenge would, I think, have been sympathetically received, and it asks whether the similarity on which judge has paid his finding of copying so that Marguerite has incorporated a substantial part of Helen's book, skilled labor in design Asia, and I think that the Court of Appeal in disagreement with the judge would have said that it did not study the case. But the finding of copying were not challenged, and in any event, finding on such matter are particularly the province of the trial judge in Biogen INC Millett PC, my noble learned friend Hoffmann commented, where the application of the legal standard has negligence obviously involves no question of principle, but is simply a matter of degree. Appellant court should be very cautious in differ from judge evaluation, page 45. The same caution should, in my view, be employed related to evaluation about similarity and substantiality. See also Buxton, Lord, and ours in this case. So, yeah. As ongoing, we have many case law, and if you're a person who like to study the case law, that's very interesting. So for this reason, and though even my notable and learned friend Lord Bingham, Cornhill will speak, I have advantage reading in draft, I would allow the appeal. So that's the conclusion of the case. So the way we just go again for the conclusion, and then we will end up this discussion with this morning. So again, see again a conclusion. In my opinion, there are two respects in which the Court of Appeal approach went wrong. First, the conclusion seemed to me to contradict the judgment finding no copying. More important, however, the approach whereby the constituent feature of the rival design were isolated from whole and compared with one another was, in my judgment. In a case where copying has been found established and the findings were not under challenge, wrong in principle. The Margarita design were an auto copy. The question whether the copy constitute an infringement is raised a question of substantiality, but a question that had to be determined by comparing Margarita as a whole with Asia as a whole. Did Margarita incorporate a substantial part of the skill and labor expended by design of Asia in producing Asia? The judge had found that it could not otherwise and make it finding of copying. There has been no direct evidence of copying, and the judge finding that been based on the extensive similarity between Asia and Margarita. The similarity, coupled with opportunity to copy and in absence of any acceptance evidence from RWT and to an independent provenance from Margarita, and led the judge to conclude on a balance of probability that Margarita has been copied from Asia. If the similarity between the two works was sufficient to justify the interference that one has been copied from another, there was, in my judgment, no further part of the concept of substantiality to play. The thrust of Morris L.J. judgment in the present case suggests that he disagrees with the basis on which the judge can arrive at his finding of copying. If the judge's finding of copying has been challenged in a court of appeal on the ground that the similarity between Asia and Marguerite were not sufficiently substantial to justify the inference that Marguerite has been copied from Asia, the challenge would, I think, have been sympathetically received, and if asked whether the similarity on which the judge has based his finding of copying so that Marguerite has incorporated the substantial part of Allen's book, Skill and Labor, in designing Asia, and I think that's the Court of Appeal disagreement with the judge would have said that it not. But the finding of copying were not challenged, and in any event, findings on such matter are particular to province, trial judge, biogen meter, where the application of legal standard is significant and obvious. Involve no question of principle, but is a simple matter of degree, and appeal court should be very closely different from just evaluation. So that's the case for today. We take a report from Intuitive Intellectual Property Petition, 21 October 2021. Thank you for your listening.